Hello, and welcome to Barcast Audio. This is the Constitutional Law Face Punch Essay Workshop. As you may remember, in most jurisdictions, the majority of your points on the essay portion of the bar exam come from your analysis, meaning that you can completely whiff on one or two elements of a rule statement, but so long as you manage to link the facts of the hypo with your semi-made-up law, you'll generally be able to come away with enough points to pass the essay. This workshop is designed to help walk you through a con law essay. Let me preface this audio lesson by saying that this is generally going to be shorter than most of our face punch essay workshops. The reason for that is because constitutional law questions are generally going to be shorter than most other subjects that pop up on the MEE. The unfortunate reality of con law on the MEE is that a lot of the time, these questions are only testing one or two con law issues. So if you whiff, you whiff. I don't say that to psych you out. In fact, if you prepare correctly, these questions can actually provide a tremendous opportunity. Because of the broad scope of the subject and the specificity of the con law questions asked on the exam, these questions can provide a unique opportunity to score a lot of points based on a relatively small amount of writing. Con law questions tend to run shorter than the average hypo, leaving you less facts to pull and connect. But if you're able to accurately analyze the facts that are presented, you can score more points in less time than you would typically spend on an MEE question. The catch-22 here is that when faced with a con law question, you need to spend an extra minute to make sure you're accurately identifying the issue being tested. Generally, con law essay questions on the exam are going to fall into one of 5 buckets. 1. Judicial review. 2. Separation of powers. 3. Federalism. 4. 5th/14th Amendment questions. Or 5. First Amendment questions. I want you to listen through the question with these buckets in mind, so you can work on identifying which buckets the facts are invoking. For our example, we're going to be working through the February 2015 MEE Constitutional Law essay. You can easily access this essay on the NCBE website or by Googling February 2015 MEE questions. I'll begin by reading the question. Take special care to note to yourself any issues and facts that stick out to you as I'm reading. I suggest you rewind and listen through the question twice before attempting to tackle it. All right, without further ado, let's get started. State A, suffering from declining tax revenues, sought ways to save money by reducing expenses and performing services more efficiently. Accordingly, various legislative committees undertook examinations of the services performed by the state. One service provided by State A is firefighting. The legislative committee with jurisdiction over firefighting held extensive hearings and determined that older firefighters, because of seniority, earn substantially more than younger firefighters, but are unlikely to perform as well as their younger colleagues. In particular, exercise physiologists testified at the committee's hearings that, in general, a person's physical conditioning and ability to work safely and effectively as a firefighter decline with age, with the most rapid declines occurring after age 50, and that, as a result, firefighting would be safer and more efficient if the age of the workforce were lowered. State A subsequently enacted the Fire Safety and Employment Act, the Act. The Act provides that no one may be employed by the state as a firefighter after reaching the age of 50. A firefighter, age 49, is employed by State A. He's in excellent physical condition and wants to remain a firefighter. His work history has been exemplary for the last 2 decades. Nonetheless, he has been told as a result of the act, his employment as a firefighter will be terminated when he turns 50 next month. The firefighter is considering A, challenging the act on the basis that it violates his rights under the 14th Amendment's Equal Protection Clause, and B, lobbying for the enactment of a federal statute barring states from setting mandatory age limitations for firefighters. 1. Does the act violate the Equal Protection Clause of the 14th Amendment? Explain. 2. Would Congress have authority under Section 5 of the 14th Amendment to enact a statute barring states from establishing a maximum age for firefighters? Explain. All right, now that we've read through this essay, which issues stuck out to you? Take a moment and try to think through what the issues were. I'd suggest you go back and listen to the hypo again, just to get into the practice of identifying these issues as you're reading or listening through them. Okay, so before anything else, which buckets do you think these facts fall into? Well, the first thing that should have jumped out to you, even before you took the time to read the questions, is that this is clearly a classification being made here. And when there is a classification being made, your mind should jump quickly to the Equal Protection Clause and the 5th/14th Amendment bucket. Additionally, the facts here indicate that Congress is attempting to enact a statute barring states from setting mandatory age limitations. Just what exactly is being tested by this issue is a little murky, but it certainly appears to be a separation of powers issue as to the extent of Congress's authority. So here, the classification being made is on the basis of age. State A here is attempting to weed out firefighters who get too old. We know that the 14th Amendment provides that different levels of scrutiny will be applied to different kinds of classifications. We have strict scrutiny for suspect classifications, intermediate scrutiny for quasi-suspect classifications, and rational basis scrutiny for non-suspect classifications. So naturally, the first question you should have under equal protection is age a suspect or quasi-suspect classification? What are our suspect classifications? Remember our near classifications. They are first, national origin, second, ethnicity, third, alienage, and fourth, race. Age is clearly absent from these, so next we have to look to whether age is a quasi-suspect classification. Well, there are only two quasi-suspect classifications, and those are gender and legitimacy of non-marital children, so once again, age isn't among them. That means that age is a non-suspect class, so any classifications based on age would be subject only to rational basis review, the lowest level of equal protection scrutiny available. Rational basis review places the onus on the challenging plaintiff to prove that the state's classification is not rationally related to a legitimate government interest. Note that this is an incredibly high standard and that the state's classification is almost always upheld under this classification. So let's apply this review to our facts. The burden would be on the firefighter to prove that State A's interest in weaning out older firefighters is not rationally related to a legitimate government interest. And under the facts presented, it is highly unlikely he would be able to do so. State A will likely argue that this age limit is being put into place to reduce both expenses and improve firefighter work quality. This will stand as a legitimate state interest, given how low the threshold is. Further, the facts here indicate that the state is basing its classification on its reasonable belief that the skills required to be a competent firefighter decline with age. In fact, it is specifically stated here that the state legislature heard evidence from exercise physiologists supporting this conclusion. That brings us to the second issue being tested, whether Congress's statute prohibiting states from imposing age limits would be valid. Let me start by making a confession. The first time I did this essay, I completely whiffed on this issue, and I'm guessing I'm not alone in saying that. It turns out the rule being tested here is actually the requirement stemming from Section 5 of the 14th Amendment, that Congress's enactment of law be congruent and proportional to the constitutional injury to be prevented or remedied, and the means adopted to that end. Congress's enactment of a new state law is proportional when the law enacted outlaws conduct held unconstitutional under existing judicial precedent. However, Congress lacks such authority where there is no constitutional injury. Here, State A's act of discriminating on the basis of age would not be an unconstitutional classification, so there was no constitutional injury to be prevented or remedied. As such, Congress would lack the appropriate power to enact the statute barring age requirements for firefighters. And that's it. Those are the only two issues being tested here. This is one of those all-or-nothing situations. But remember, like I said before, these con law essay questions can provide an opportunity. If you can come up with some semblance of an answer that makes sense, that law graders are looking to give points on, you can come out with a 5 or a 6, depending upon the grading of your state, just based on the fact that this essay question would throw a wrench into the plans of most essay takers. This concludes our Con Law Face Punch essay workshop. Thank you, as always, for listening to Barcast Audio, and I'll talk to you soon. Bye now.